Lord Anderson, can you just give me a second
Yes, of
now
course.
to make sure that my equipment is working, which I hope it will be. Yes, okay.
I'm grateful to your Lordships for moving the court.
And I
My
hope
understanding is that the link to the live stream is now available to anyone who goes onto YouTube. And
Well, I hope that you'll get a message that Mr. Shvidler can hear the proceedings and see the proceedings now, as he should have been able to this morning.
I'm grateful, my Lord.
Rest assured, I shall be investigating one.
No, I'm told not yet, but we've hardly begun, so hopefully things will
Go and check.
improve.
I mean, just be assured, Lord Anderson, that had I known in advance, I would not have sat without rectifying the situation. I'm very sorry, and I would ask you to apologise on the court's behalf to your client,
I'm very grateful.
because we like these things to work.
Lord, shall I continue and we'll
Yes,
see
please,
how we go?
please. I mean,
Did
you're
I say?
still on the regulation.
Yes, we're not too far to go, but we were on Regulation 6, the designation criteria. We'd already looked at the purposes under Regulation 4. We looked at the categories of involved person provided for in Regulation 6.2, and we were on Regulation 6.4 to see what it means to be involved in obtaining a benefit from or supporting the government of Russia. And 6.4c says carrying on business in a sector of strategic significance to the government of Russia, and D says working as a director of such a business. In terms of what businesses are caught by 6.4c, there is a list over the page on page 126. So it's the Russian chemicals sector, construction, defence, electronics, energy, extractives, financial services, information, communications, digital technologies, and transport. And Mr. Shvidler makes the point in his evidence. I don't want to detain the court longer than I need to, so I won't take you to it. But it's in his second witness statement, at paragraphs 162 to 166. That is the supplementary bundle, pages 302 to 303. He illustrates the breadth of that category simply by reference to the extractive sector, by reference to other FTSE 100 companies. Of course, Evraz PLC, of which Mr. Shvidler was a director until March of 2022, is a FTSE 100 company. And so, he points out, is BP, and so is Shell. And he gave some examples of chief executive officers of BP and other board members who obviously are caught by these designation criteria. I'm quite sure nobody ever thought of designating them. Why would they? And he details the involvement of those companies, particularly BP, in the Russian extractives sector. Then the other possibility is association, and we see that in 6.2d. It's enough to be a member of or associated with a person who is or has been so involved. And I repeat the point that I made when we were looking at the Act. If you look at 6.2, the definition is a person who is or has been involved in either of those two things. And then the remaining subparts of subsection 2 are governed by that. So owned or controlled by a person who is or has been so involved, acting on behalf of a person who has been so involved, and here associated with a person who is or has been so involved. And that's why I say you can't designate someone on the basis that they are an associate of an associate. You need to be an associate of somebody who has either been destabilizing Ukraine or obtaining a benefit from or supporting the government of Russia. But all the same, association is a very broad concept. And you see that from page 125, subparagraph 6, where it says in paragraph 2d, being associated with a person includes obtaining a financial benefit or other material benefit from that person, being an immediate family member of that person. So if one is looking at the scope of these designation criteria, and those who might notionally be subject to designation under them, one is looking not only at blameless British directors of BP, you are looking potentially at their immediate family members. And if you look over the page again to 126 in subsection 7, you see a very precise definition of immediate family members. Wife or husband, civil partner, parent, step-parent, child, stepchild, niece, nephew, grandparent, and so on. And indeed, as we'll see, the Foreign Office seek to interpret subsection 6 more broadly still. They fasten on the word includes, and they say, well, it's plainly not limited to people who obtain financial benefits or immediate family members. So why shouldn't it include friends or general business associates? Or I imagine they might say family members who are not immediate. So there will be an issue for the court to resolve in terms of the interpretation of that sub-clause. Regulation 7, I think I can leave. I'm afraid we will have to come back to it when we're looking at the issue of owned or controlled. But it's slightly intricate stuff, so I think it's probably better to address it in the context in which it arises. Regulation 8 requires notification. 8.2a, once a person has been designated, then they must be informed and the designation must be publicised. And indeed, they are all published on a register that anyone can consult. And under 8.3, there must be a statement of reasons. Can I just check that the live stream is? Okay. I'm delighted to say what it is. So renewed thanks for making that possible. Regulations 11 to 15, again, I'll just show you the headings of these, but these are effectively the financial regulations, providing for asset freeze, making funds available to persons and for the benefit of persons. Same thing with making economic resources available to the benefit of persons. Then at Regulation 19, there is a broad anti-circumvention prohibition. So I think that's all we need for now of the regulations. Can I turn to the process of designation? And the decision under appeal, as I've said, is the amended designation of the 1st of November, sorry, I think it's the 11th of November, 2022, which revised the original designation of the 24th of March, 2022. But since our case is that this designation was arbitrary, it is relevant to spend a little time on how the process by which the original designation and the revised designation were arrived at. And this topic is developed at paragraphs 7 to 9 of our skeleton argument. And for your lordships and your ladyship's reference, though I don't need to take it to you now, there is a full chronology in the core bundle at tab 5, that's page 67 and following. Well, I also invite your attention to a few pages that were obtained from the Foreign Office and the Department for Transport in October and November 2023, after the judgment of Mr. Justice Garnham and indeed the lodging of this appeal. My friend doesn't like those pages, but equally he makes his substantive submissions on them. Our case, if it should arise, is that these are materials that could not have been obtained with reasonable diligence, that are reliable because they are all communications from within government, and they could have an effect on the result. So the Ladd and Marshall criteria, should it be necessary to apply those, are satisfied. The story basically was a series of requests, data subject access requests, and requests.
We have no objection from Sir James.
No, well, in that case, let's just go straight to them without any further ado. And perhaps I could take you to those documents. They're not very many pages, but they're at the very start of the supplementary bundle, the first tab. And you'll see if you go to that first page that this is a composite of various sources that were received from the government in many cases after a very great deal, many months of trying and very considerable delays, but we've got them now. There's a data subject access request provided by the Foreign Office, 27th of October. Same thing from the Department of Transport, 6th November, and then another one, attachments. So that's the terminology that you find in the left-hand column, and this is a chronological composite. And I can really summarize my points under this head by reference to these communications. And you see that all this started with a jet aircraft belonging to Mr. Shvidler that landed at Farnborough. And it was on the 6th of March, at the bottom of page 2, you see an email from DFT to other DFT officials saying, issue, as requested, we have to consider whether aircraft LX-Fly breached the restriction of flying regulations.
I just want to follow this. Where are you exactly?
I'm at the bottom of page 2.
The bottom of page 2.
Penultimate communication on page 2.
Of your number.
Supplementary hearing bundle. I think they're called extracts from DSAR digests.
And what I'm looking at is issue as requested. Yeah?
Yes.
Okay, thank you.
Yes. So whether it's a restriction of flying regulations, and if not, what options are available to hold the aircraft. Recommendation that you note that we do not have enough evidence to hold the aircraft for breach of our restriction on flying regulations, and that you consider the options set out in the table. That's at 9:44 in the evening. Then over the page, 9:59, again, this is all internal Department for Transport. As requested on Friday, officials have prepared the attached note considering whether the aircraft has breached restriction of flying regulations and what options are available to hold the aircraft. Farnborough Aircraft and NATS will notify DFT officials if a flight plan is filed.
So what are the restriction of flying regulations?
They are regulations that enable aircraft to be detained.
Are they sanctions?
No, nothing to do with sanctions.
Nothing to do with sanctions.
They're to do, I think, principally with airworthiness. They're all about air safety.
Air safety.
And there's nothing unsafe about this Shvidler's plane. But someone had looked at the flight logs, seen that this plane was landing at Farnborough, and thought, what should we do about this? So they started thinking, first of all, about the option that they had for immediate detention, which is about air safety. And the note over on page 3 that was attached to the communication of 9:59 said that the aircraft had landed at Farnborough, was reported to have links with Eugene Shvidler, a Russian oligarch. Well, he's not Russian. You, Secretary of State, have requested advice as to what powers Secretary of State for Transport has, or powers that could be transferred to them to detain this aircraft or prevent it from departing the UK. The Secretary of State at the time being Grant Shapps, who's somebody who knows and understands something about aviation. Background, aircraft is currently parked, registered in Luxembourg, no information about ownership, no evidence about where Mr. Shvidler is ordinarily resident, no evidence it would fall within the scope even of ROF, and then something is redacted, and then it says this will not affect this aircraft since FCDO have confirmed that Shvidler is not currently on the sanctions list. Any actions to designate Shvidler would need to be agreed across government. Then the sanctions unit of the FCDO enters.
As at the 6th of March, had there been people sanctioned? I'm sorry, I don't remember the complete chronology. Had there been a series of sanctions in relation to Ukraine?
Yes.
There had.
The invasion had been a couple of weeks earlier. I think Mr. Abramovich was one of those who'd already been sanctioned by this time.
Sorry, I just didn't have the
and others as well.
in my head.
Yes.
Yeah. Okay, thank you.
They wanted to check whether Mr. Shvidler was one of those. Then the sanctions unit of the Foreign Office comes in, 6:49 the following evening, at the bottom of page 3. This is again internal to FCDO. I wanted to check in with you regarding handling of the below. Shvidler is not designated by the UK and not captured by connected to Russia. Don't know much about Shvidler. According to a quick Google, he's a Russian businessman living in the US with links to somewhere we're not allowed to know about. I want to avoid the situation in which we are asked to designate him at short notice to stop this flight. We don't know much about him, his assets, or whether he falls within scope of our sanctions regime. It is also a sledgehammer approach to a specific issue. Well, some of us may remember the original description of proportionality in English law. I think came from Lord Diplock, who described it as a steam hammer to crack a nut. But anyway, this is a sledgehammer approach to a particular issue. And then the response also from the Foreign Office was, thanks, I agree. No question of actually applying sanctions on that timescale, or even whether it's advisable. I assume the aircraft isn't registered either, so no immediate enthusiasm. I was wrong in saying Mr. Abramovich had already been designated. He, in fact, was designated on the 10th of March, so a few days after this conversation. And I won't take you right through all this, but if you go on to page 8, you have the Treasury coming in on the 17th of March in the bottom box on page 8. And they were sceptical, even as late as the 17th of March, about whether Evraz or Mr. Shvidler, by extension, came within the scope of the sanctions regime. So they'd examined some documents. They thought the evidence they had, this didn't bring Evraz in scope. Very interesting in view of what is now submitted. We appreciate this is only a preliminary view. We do not feel there is sufficient material evidence to show that the two Abramovich-appointed directors could in reality control Evraz. Interesting on the issue of ownership and control. In particular, there are 11 directors in total. 6 of them are non-executives. We see no evidence that the 2 could direct Evraz over and above the others. The evidence provided has been primarily anecdotal in nature, would not meet the bar for OFSI to take enforcement action. For example, whether Shvidler is Abramovich's best friend seems highly subjective and easily capable of rebuttal, even if he was gifted a yacht. Well, in fact, he wasn't. They alleged that he was, but they then resiled from that. You see no evidence of joint arrangement and so on. Although between Abramovich, someone else, and Shvidler, they own more than 50% of the shareholding, as neither the other person nor Shvidler are subject to financial sanctions, it would not contribute ownership unless it could be shown they were controlled by Abramovich, which we've not seen sufficient evidence for. So considering the above and the evidence we've seen so far, Office's view is that Evraz does not fall under the scope of the sanctions regime, but they'd be happy to re-examine that. Then the Foreign Office come back with a reference to a company called Milhouse, which turned out to be a red herring, and we'll come to that. Then the DFT on the 18th of March, again, a lot seems to be, these civil servants are working late, just before 8 o'clock in the evening. No real comments, strongly support getting the ROF in place ASAP and tweeting out that we've got another one. So you can see where DFT were coming from. And then I think this is slightly earlier in the same evening, the bottom box says, see submission regarding another aircraft that's landed at Biggin Hill. And this is another aircraft belonging to Mr. Shvidler. Therefore, should Secretary of State wish to sign this ROF, it will be ideal if it's signed before midnight on Sunday, 20th of March, because they were planning a flight out of UK. So officials have become aware of this further aircraft at Biggin Hill, also connected to Shvidler, and agree to make ROF, as the recommendation, to restrict GLATO's access to UK airspace while investigations continue, and sign the ROF. Over the page, 19th of March, thank you for this submission. Secretary of State agrees with the recommendations and to sign the ROF. He would also like a tweet to be drafted on this. And so immediately a tweet is asked for, and a draft is set out, and there's various correspondence about the tweet. Then at the bottom of that page 10, we have the Foreign Office. This is sent on a Saturday, 2 o'clock in the afternoon, and Foreign Office to DFT, over the page, page 11. Hi both, our Secretaries of State were in touch again today about this case. I should say the Foreign Secretary at the time was Liz Truss, and the Secretary of State for Transport was Grant Shapps. I know the teams were working up a case on Friday. Given the complexity, it would be much safer to conclude this on Monday. Can the plane be held until then? Of course, it was on Thursday that the Treasury was expressing scepticism. The teams were working up a case on Friday, and they're saying on Saturday, could we possibly wait until Monday to complete the process? Then the fourth box down, still on Saturday, this time 10 to 11 at night. Anyone who thinks civil servants don't work hard really needs to read this correspondence. Internal within the Foreign Office, a couple of things to hand over. Shvidler, one of Abramovich's key associates, 2 of his planes have now been held by DFT. Foreign Secretary asked if we could sanction him over the weekend, having been lobbied by Grant Shapps. But it's a complex case. He is US, Israeli, Russian. Well, he's neither Israeli nor Russian. So we will not resolve before Monday. DFT content with that, but it may come back again. So due consideration is being given, and I think late on Saturday night they might be able to wait till Monday. Then more correspondence about handling issues and so on. And I think the next thing that happened was that he was eventually sanctioned, and I can leave this correspondence now, on the Thursday, the 24th of March, and that was celebrated by Miss Truss and Mr. Shapps in the terms that we set out in our skeleton argument at paragraph 7. So you see a press release on the day of the designation in which Foreign Secretary Liz Truss said these oligarchs, businesses and hired thugs are complicit in the murder of innocent civilians, and it is right that they pay the price. And 2 days later, Grant Shapps described Mr. Shvidler as one of Putin's cronies and said Putin's friends who made millions out of his regime will not enjoy luxuries while innocent people die. He did, to his credit, eventually remove that tweet when he was asked to do so, because plainly no one suggests that Mr. Shvidler is a friend of Putin or a crony of Putin. And then indeed there was a further tweet of 8th of April in which Mr. Shapps continues to describe Mr. Shvidler as a crony, this time with a professional video of Mr. Shapps standing in front of his plane. And that the reference to that is at supplementary bundle, page 69. So if I just take you to what the respondent says about the designation, it's at 4.2 of their skeleton. It's at page 45, you've probably taken it out, but it's page 45 of the bundle. And this is in the context of the argument on proportionality. 4.2, second sentence. In considering whether and how the appellant's designation could contribute to the achievement of the objectives of the 29 regulations, the Secretary of State assessed what he perceives to be effective pressure points for the purposes of influencing the strategic calculations of the government of Russia and all persons carrying on business in sectors of strategic significance to the government of Russia. The identification of foreign policy levers by which to influence the government of Russia's behaviour in relation to Ukraine is a matter in respect to which the Secretary of State has considerable expertise. Well, Lords, if that is meant to suggest some rationally and considered basis of the possible targets for sanctions from which Mr. Shvidler was selected, then with respect, it is not an accurate picture of how the decision was arrived at in Mr. Shvidler's case. The effective pressure in this case was the pressure placed by Mr. Shapps on Miss Truss to provide a legal basis for detaining Mr. Shvidler's planes and publicising the fact that he had done so. And that is how the original designation came about. We would describe it as a politically driven exercise in gathering evidence at speed to provide legitimacy for a decision that had already been made. Lords, the reasons for the designation, they're not provided the moment you're designated. You go on the list and you get your reasons later. And the reasons were provided to Mr. Shvidler some 3 months, or almost 3 months after his designation, on the 16th of June 2022. And I can take you to that very briefly. It's in, again, the supplementary bundle. It's tab 4 of that bundle, and it's page 24. The reasons take the form of a sanctions designation form, a so-called SDF, which is accompanied by a bundle of evidence in support, a so-called SDFE. We didn't put the SDFE in the bundle because this is the original designation, not the one that's being challenged. But most of the evidence is taken from websites and newspaper articles and so on. So you'll see at the top of page 24, there's an explanation of what the SDF is. It's a document we use to set out the justification for designating or listing a person. And your Lordship should just see one passage from the conclusion at page 30, on which sets out the reasonable grounds to suspect, it's at the bottom of page 30, that Shvidler is associated with a person who is or has been involved in destabilising Ukraine, or undermining or threatening the territorial integrity, sovereignty or independence of Ukraine, or obtaining a benefit from or supporting the government of Russia. And that person is Roman Abramovich. You see the allegation, which really leaps out of this document, that he's been involved in destabilizing Ukraine, and is or has been involved in obtaining a benefit from or supporting the government of Russia through carrying on business in a sector of strategic significance to the government of Russia. And that's a reference to his directorship of the FTSE 100 company Evraz plc. And over the page, in summary, the evidence has explained the activity that has occurred, that has destabilized Ukraine and undermined or threatened its territorial integrity, sovereignty or independence by Russia since 2014, described who Shvidler is, situated him in relation to Abramovich, and then demonstrated how Shvidler is associated with Abramovich as an involved person, and then how through, at the time, various financial interests were relied on. That's now been reduced just to the directorship of Evraz. He had been involved in obtaining a benefit from or supporting the government of Russia. So that was the original designation, and the high point of the case clearly was the association with someone who had been involved in destabilizing Ukraine. Mr. Shvidler then took advantage of the right given to him by Section 23 of SAMLA to request the revocation of his designation. But the revision of the designation, which came along in November, did not result in its strengthening. And I'm going to take you to that in just a moment, but may I make just some general points before I do that. First, not a single new piece of evidence was added to the file between the original designation of March and the revised designation of November. No reason why it shouldn't have been, but it wasn't. Secondly, there was a retreat from the allegations that you've just seen in the original SDF into the minimalistic and highly technical basis for designation that it is now sought to defend as proportionate. In particular, no reference was made to the supposed role of Mr. Abramovich in destabilizing or undermining Ukraine. And it was not sought to suggest that Mr. Shvidler's shareholding in Evraz or indeed in any other company could justify his designation. Fourthly, reference was also removed to various ways in which it had been said that Mr. Abramovich gave Mr. Shvidler a financial benefit, for example, that he'd given him a yacht. And there was also a suggestion in the revised designation, revised SDF, I think I'll leave it there for now just for the sake of simplicity, but I will take you to the SDF, which is, again, in the supplementary bundle at tab 7. It begins at page 98, and you see the same rubric at the beginning about what an SDF is. This time, at tab 7, at tab 8, we have the SDFE, so we do have the evidence pack this time around. You'll see if you look at page 110 that the types of information included in this pack are open source, company registration and website information, and the total number of sources is 10. So going back to the SDF itself, page 99 sets out the sanctions measures that are being proposed, the asset freeze, or indeed which by then had already been adopted, the asset freeze and the transport sanctions. Nothing at the time about trust services, because that only came along in 2023. At page 100, a very helpful feature of these SDFs is that the Foreign Office highlight, they give you Regulation 6, and they highlight the bits of it that they are relying on for the particular designation. And you can see they've highlighted is or has been involved in obtaining a benefit from or supporting the government of Russia. That's the directorship of Evraz plc, and associated with a person who is or has been so involved, that is association with Mr. Abramovich. And then they explain which parts of those definitions they're relying on. You see it's 4C and D, that's being a director of a business in a sector of strategic significance, the extractive sector. And you see associated at subparagraph 6, they're relying on financial or material benefit from that person. They're not suggesting an immediate family member. it seems that you tick one or other of those boxes. That seems to be the way it's set out. And then the Russian extractive sector is identified on 101. Then proposed statement of reasons. Eugene Shvidler is a business partner of Roman Abramovich, with whom Shvidler has maintained a close relationship for decades, and from whom he has obtained financial benefit. Shvidler is therefore associated with a person who is or has been involved in obtaining a benefit from or supporting the government of Russia, one, by owning or controlling, directly or indirectly, Evraz plc and its subsidiaries, and two, by carrying on business in sectors of strategic significance to the government of Russia, namely extractive, construction and transport. Shvidler is a former non-executive of Evraz. As such, Shvidler has been involved in obtaining a benefit from or supporting the government of Russia by working as a non-executive director of Evraz, an entity carrying on business in a sector of strategic significance to the government of Russia. And then going over to 103, there is more detail here about Abramovich's designation. And you see at the top of 103 that he was originally sanctioned, as you've seen from the earlier SDF, for his involvement in destabilizing, etc., Ukraine. And that designation was then varied, no doubt as a consequence of representations made by Mr. Abramovich, on the 23rd of August. And you'll see that there are still 4 bases for Abramovich's designation, but only 2 of those are relevant to Mr. Shvidler's designation. So the first one is he's associated with Putin. The second one is he's associated with Alisher Usmanov. And then the third and the fourth are the 2 that are relevant here. In fact, you've already seen them in the summary of statement of reasons at page 101. These are basically his links with Evraz and with Evraz's business or businesses. And then the 5th one, Abramovich is a member or associated with a person, namely Evraz plc. You can see why the statement of reasons only referred to number 3 and number 4. That's because you can't designate someone for being an associate of an associate. And numbers 1, 2, and 5, they work against Abramovich on the basis that they make him an associate, but that cannot then be passed on to an associate of the associate. So the relevance of Abramovich for the purposes of Mr. Shvidler's designation is Mr. Abramovich's connection with Evraz, which you might say is a way of saying that there is not so much as might appear between the 2 bases for Mr. Shvidler's designation. They're both very much focused on Evraz and its activities in London. So there's then reference to a company called Sibneft in the next paragraph, and there is reference under that to a company called Milhouse, which is a holding company that manages Abramovich's assets. And it says there are reasonable grounds to suspect, those words I must say do a lot of work in this section, that Shvidler worked on behalf of Abramovich in this role. It's reasonable to infer that Shvidler would be paid in his position as chairman of Milhouse LLC. Therefore, it is reasonable to infer that he would be obtaining a financial benefit from Abramovich. Lords, I have to clear up the question of Milhouse, I'm afraid, because it's very, not only is this wrong, but it's rather revealing as to how this designation, even in its revised form, was put together. There was a suggestion that he received benefit from Mr. Abramovich for his work with Milhouse, but that was answered in Mr. Shvidler's evidence. If you look at supplementary bundle tab 9, beginning at 166, other alleged financial benefits from Abramovich. There's already been a letter from Peters and Peters explaining the position in relation to Milhouse, and he makes the point that Milhouse did not manage Mr. Abramovich's assets, but was created for the sole purpose of performing back office functions. The FCDO suggests that it is reasonable to infer that I would be paid in my position as chairman of Milhouse, and therefore reasonable to infer that I would be obtaining a financial benefit from Abramovich. This is incorrect. As explained in the letter of July, so as explained, in other words, 4 months before the revised designation, the position is that I held the title of chairman of Milhouse as a nominal title. As such, I did not attend any meetings, I held no shares, and I did not receive any remuneration. Well, Lordships might have thought, when I read you that email from my client at the beginning of the hearing, perhaps he was overdoing it a bit. But this is a really very striking example. I should say that Mr. Reid, the government's witness, doesn't respond to this. He comes in with another witness statement. He doesn't refer to Milhouse. So the only evidence on it is from Mr. Shvidler, having signed a statement of truth saying that he wasn't paid. But nonetheless, despite this being said in July, it appears in the designation form, and despite it being said in this challenge, it remains in the designation form. So you understand the work that reasonable grounds to suspect is capable of doing. There can be uncontested.
Lord Anderson, I am, fairly familiar with corporate governance.
Yes.
What was he doing if he was held the title of chairman, but didn't attend any meetings, had no shares, and didn't receive any remuneration?
Well, I mean, we could look at
does he tell us?
Well, we could look at the letter of July. I should find you perhaps the reference to that. May I come back with a reference to that, Lord? But there is a letter earlier in this bundle, which was pages 33 to 37. It's tab 5. I think paragraph 27 of that letter, which is on page 39 of the supplementary bundle. And this is a letter from my instructing solicitors, Peters and Peters, explaining what Milhouse does and what it doesn't do. And although he was chairman, it was a nominal title. He didn't attend any meetings, didn't hold any shares, never received any remuneration. Ceased working in Russia, not visited Russia, never held any position in the company now trading as MHC Services, and never received any salary or other remuneration. And 28 is, yes, well, you see that's about the back office functions. That's what Milhouse does. He wasn't there to manage Mr. Abramovich's assets. But that wasn't questioned either after receipt of the letter or after receipt of the witness statement. But reasonable to infer, apparently, that he received remuneration. So it's a demonstration of the latitude of...
Leaving remuneration aside, one would normally infer, wouldn't one, that somebody made a chairman of a company had some connection with it.
But if there is evidence...
No connection with it.
Yeah. Well, I mean, I don't know how important Milhouse is. It remains on the SDF. One could argue that even if he had been paid, he would presumably have been paid by Milhouse, not by Mr. Abramovich.
Well, it's different.
Yeah, it's right. Now it's rather a strong point. It's not a financial benefit from an involved person. Milhouse.
But my question is there any explanation of why he was made chairman of Milhouse?
I think Lordship has seen what there is.
Okay, thank you.
In the witness statement and in the letter. If there's anything more, I'll come back to you. But what has never been in dispute is that Mr. Shvidler is a friend of Mr. Abramovich, and they have a long-standing business relationship. Mr. Shvidler has always been extremely open about that. The issue in relation to the relationship...
Well, is it accepted he's a business associate then? If he's a friend and has a business relationship, presumably that means it makes him a business associate.
Well, I use the word relationship because I don't want to prejudge the meaning of the term association as it's defined in the regulations. My friend would say, yes, he's an associate.
No, I'm asking you.
Well, no, I'm not going to use that word. If you're asking me within the terms of the regulation, no, I say they're not associated.
I see.
But undoubtedly, yes, they've had a
He is a friend and has had a long-standing business relationship with Mr. Abramovich,
yes,
but is not a business associate for the purpose of the regulation.
The evidence that we have seen relied on by the government does not, we say, establish that he received a financial benefit from Mr. Abramovich within the meaning of the regulations, and of course he wasn't an immediate family member. So on that basis we consider that not to be made out. So, if I could turn to the two bases on which he has been designated, and I'll start with the easy one, the basis that he was a director of Evraz. And I can start here because it's straightforward. Yes, of course he was a non-executive director of Evraz plc, FTSE 100 company with interests in the Russian extractives sector. So we accept that he was over the threshold on that ground, just as his counterparts at BP and other companies were. But though this may have been enough to get over the threshold, it was not enough, we say, to be proportionate. And we know that. If I could take you to the judgment of the court below, paragraphs 151 to 152, we can be confident that if the only allegation that could be levelled at Mr. Shvidler was his directorship of Evraz, that wouldn't have been enough to get him designated. And if I could take you to the last page of the judgment, page 1993 of the judgment below, swiftly passing over the first sentence, it is plain from all the evidence that the reason that the claimant was designated was not just his role at Evraz, but the combination of that role with his relationship with Mr. Abramovich. That is why the other directors of Evraz to whom the claimant refers, Sir Michael
Sorry,
Peake...
I'm not with you. I'm not following you. Which paragraph?
I'm sorry, my lord. Paragraph 151.
Sorry. Many thanks. Yeah.
Page 1993.
Now got it. Yeah. It's plain from all the
Yes.
evidence. Yeah.
It was not just his role at Evraz, but the combination of that role with his relationship with Mr. Abramovich. That is why the other directors of Evraz to whom the claimant refers, Sir Michael Peake, Carl Gruber, Deborah Gudgeon and Stephen Odell, were not designated. There is no evidence to suggest that it was the race, nationality or ethnicity of those individuals played a part in the defendant's decision-making. Well, that wasn't actually our submission. Our submission was one on indirect discrimination, not direct discrimination. We'll come back to that. But we do rely on the judge's finding that he was designated not just for his role at Evraz, but for the combination of that role. And what the government said in response to our see, Mr. Shvidler said, it seems very odd that the only people designated are the ones with Russian-sounding names. And Sir Michael Peake, who was Principal Private Secretary to the current King and the current Queen, amazingly wasn't designated. And neither were all the other people with non-Russian names. It's a bit strange. And the government said, well, we can produce an objective justification for that, which incidentally they only needed anyway if it's indirect discrimination. But the objective justification is that he was also associated, as they say, with Mr. Abramovich. So that's why it's Abramovich really that is the key to this designation, and why just being a non-executive director of a company with interests in Russia would not, one may infer, have been enough. So that's why I trouble your lordships and your ladyship with the other basis for designation, notwithstanding the fact that I accept that he was over the threshold on the basis of his directorship. And still in the supplemental bundle, if we go to back to page 103.
Moved on to basis 2 now.
Yes, I think actually they were put the other way round in the. Yes, I think they were put the other way round in the SDF, pages 101 and 102.
Anyway, supplemental bundle page
103. In fact, the heading is at the very bottom of 102. How is Shvidler associated with a person who is or has been involved in obtaining a benefit from or supporting the government of Russia? And you'll see that we've seen already the basis for designating Abramovich. They dropped the destabilising. They found 4 grounds. The 2 that mattered for Mr. Shvidler's purposes are numbers 3 and 4. And if you go back to 101, it is 3 and 4 which are used in the description of Abramovich. All that is perfectly consistent with the principle that you cannot designate someone on the basis that they are an associate of an associate. So the justification for sanctioning Mr. Shvidler on the basis of his so-called association with Mr. Abramovich is not Mr. Abramovich's association with Putin or indeed Mr. Usmanov. It's his alleged ownership and control of Evraz and his carrying on business in the extractive sector. And that is important for when we come on to proportionality. So after that lengthy, but I hope helpful introduction, my lord and my lady, I come on to my grounds of appeal. Mr. Shvidler, as you will have seen, was given permission to appeal on his ground 1, proportionality, but not on his ground 2. Of course, we respect that, as we must, but that is not to say that considerations of discrimination, or to put it another way, arbitrariness, are irrelevant to the proportionality issue. And I will come back to that in due course. But we have 5 grounds of appeal, and they're set out. I think we can now leave the supplementary bundle for a while. They're set out in the core bundle at tab 2. That's page 13 of the core bundle. And just to give you an overview, you'll see that the first one relates to the standard of review generally. The second, which has 3 limbs, relates to the finding of an association with Mr. Abramovich. The third, fourth and fifth grounds relate to the manner in which the learned judge performed the 3 principal steps of the proportionality analysis. And I will take them in turn. But before I do that, I should confess that through my own fault, they are incorrectly numbered in my skeleton argument. And if your lordships are backward enough to have that document in hard copy, as I do, perhaps I could ask you, please, just to correct that. On page 27, under the heading Grounds of Appeal, the first one, proportionality, the proper approach, that should be recorded as ground 1A. Then on page 30, number 2, association with Mr. Abramovich, that should be ground 1B. On 32, I think the lordship's getting the hang of it, that's 1C, rational connection. 39, alternative measures, that should be 1D. And 40, fair balance, that should be 1E. I apologise for all that confusion. And I start with ground 1A, which is the standard of review. And just for reference, that's dealt with at judgment 87 to 97, paragraphs 87 to 97, and our skeleton paragraphs 31 to 40. And I'll start, if I may, by identifying 5 areas of common ground on the standard of review, I hope conveniently by reference to the judgment below. So, first of all, there's no dispute about the 4-part test, which is set out at paragraph 80 of the judgment below, by reference to Bank Mellat and the judgment of Lord Sumption. The 4-part test, whose evolution is described in Bank Mellat and which reached its canonical form in that judgment. Secondly, at 81 to 82 of the judgment, there is no dispute that the objective of the scheme for Russian sanctions is sufficiently important in principle to justify the limitation of the fundamental rights of designated persons. And that's the first of Lord Sumption's tests, whether its objective is sufficiently important to justify the limitation of a fundamental right. That's not a test that is specific to any given designated person, but obviously the objective of the scheme is sufficiently important. But thirdly, 83, as the judge rightly says, and again this is common ground, the fact that the scheme as a whole is plainly proportionate to the objective in view does not address the separate question whether the making of an individual designation is necessarily proportionate. And that is common common ground, and I imagine it's common ground also that, to the extent relevant, the burden of demonstrating proportionality rests on the respondent, the government. Then fourthly, going on to 89 of the judgment, the fact that this case concerns, as we've seen, foreign policy, and indeed international peace and security, does not mean that we are here in an altogether forbidden area for the court. The Al-Rawi case is cited on that point. And indeed, it's also common ground, going on to 90, that there are matters of executive judgment relating to foreign policy to which special weight should be accorded. It's simply that my learned friend and I differ as to the extent of those matters. And then the fifth piece of common ground is at 95 to 97 of the court's judgment, where the point is made that it is permissible for the court on a proportionality challenge to have regard to all the evidence explaining the Secretary of State's reasoning, even evidence or statements which expand on and amplify the reasoning already set out in the SDF, as I said at 96, and that's the Belfast City Council and misbehaving point. I should say the weight to be given to that evidence is disputed. What we'll see is that Mr. Reid, after the SDF came into force, sought to gloss fairly extensively the basis on which it was said that these sanctions could be useful. And we'll have to look at that gloss, and your lordships will have to determine what weight to give it. But we accept that it's open to the court to have regard to it. So what divides us under this head is the appropriate standard of review. And we submit, it's really an answer to a question from Master of the Rolls earlier on, we submit that the court fell into error both by how it described that standard and by how it applied it. And in terms of how it described the standard of review, which is really our ground 1A, I'd refer you to paragraphs 91 and 92 of the judgment of the court below. And paragraph 91 begins by referring to close scrutiny, but close scrutiny of what? He says, undoubtedly, this is a case where close scrutiny is necessary in order to adjudicate on a complaint that convention rights have been infringed, and it is the structured analysis articulated in Bank Mellat that must be applied. But the court does not assume the role of primary decision maker on issues that turn on the exercise of judgment or the determination of policy, limiting itself instead to asking whether the decision was one properly open to the executive. It will recognise the constitutional competence of the Secretary of State and his officials on matters of foreign affairs, attaching particular weight to the judgments of a primary decision maker with special institutional competence who's considered all the relevant material. And now we come to the close consideration. Applying that approach, the court must consider closely the particular question that falls for decision so as to gauge the extent to which it should defer to the expertise of the Secretary of State and the extent to which it can itself form a judgment. And then, in my view, he says the question as to how far the evidence relied on by the Secretary of State supports the contention that designation could contribute to achieving that objective is not entirely a question of United Kingdom foreign policy, nor is it a subject on which the court should necessarily be slow to interfere. The Secretary of State is the primary decision maker under the statute, but the court is well placed to judge the reasonableness of his analysis. Well, we'll see how this formulation played out in practice, but we draw your lordship's and your ladyship's attention to this. What the court seems to have understood, at least principally by close scrutiny, is in the first sentence of 92. The purpose of close consideration is to gauge the extent to which the court should defer to the expertise of the Secretary of State and the extent to which it can itself form a judgment. That's rather different from what we say is appropriate in a case such as this, which is close scrutiny of the basis for designation. Then the second error is in 91, where the court, we say with respect, falls into error because it sets up a false dichotomy. In fact, you see it both in 91 and you see it in the penultimate sentence of 92. A dichotomy between being a primary decision maker on the one hand and on the other, asking itself whether the decision was one properly open to the executive, and then judging the reasonableness of his analysis is the way they put it in 92. We agree that the court is not the primary decision maker, but neither, we submit, is its role restricted to the rationality analysis that is suggested here. The correct position is between those two poles, and I will remind you of the law on that in a moment. And though the picture is, we accept, clouded at 92 by the judge's reference to the court not necessarily being slow to interfere on grounds of institutional competence, the reality, as we will see when we come to limb 2 of the test, the rational connection test, is that the court below, and indeed the other limbs, having satisfied itself that this was an area where foreign policy expertise had been applied, took a very hands-off approach indeed. And it's not just limb 2, it goes for limbs 3 and 4. And you'll see that the last sentence of 92 applies the court's comments to the other limbs of the Bank-Mellat test. So this dichotomy, you're either the primary decision maker or you defer and ask yourself whether the decision was properly open to the executive, and that's, we say, a false.
If you're right, Lord Anderson, and the judge applied the wrong test,
yes,
we must state the right test and apply it ourselves.
Yes, and it would be notionally open to your lordships to remit the case, but I think your lordships have the same evidence
You're
exactly.
You're not suggesting it.
No, you have the same material that was before the judge below. The correct test for a case such as this one, we submit, is contained in the Belmarsh case and the Bank-Mellat case. And I'll take you to each of those. But before I do that, I would ask the court just to reflect a little in general terms about those cases. The facts, I'm sure, are well known to the court. Just to summarise, they are cases that arose not just in the field of foreign policy, but in the still more sensitive field of national security. The Belmarsh concerned the detention of suspected terrorists, whom it was wished to deport in the aftermath of 9/11. Bank-Mellat concerned a direction not to deal with an Iranian bank that risked being used for purposes connected with Iranian nuclear weapons programs. So in both cases, the interests of individuals have been sacrificed for the public good of protecting this country from international terrorism in one case and from Iranian nuclear proliferation in the others. Yet in both cases, the administrative measures were found to be disproportionate on the basis, we say, of a stronger judicial intervention than the court below was prepared to contemplate or think appropriate in this case. And I'll make, sorry there isn't a transcript, was provide you perhaps with a note if that would be of any assistance with my submissions, but let me make the 5 observations in the event. First observation is that in both those cases, the national security imperative for action was at least as strong as the foreign policy imperative in this case. International terrorism after 9/11, Iranian nuclear proliferation. In Belmarsh, you have 9 terrorist suspects after 9/11 at a time when the UK had derogated from Article 5 of the ECHR on the basis that there was, quote, a public emergency threatening the life of the nation. Of course, one of the issues in that case was whether that derogation was satisfactory. They held that it was. They were detained.
The applicable test can't be determined by the strength of the imperative. I mean, it could be, but there's no suggestion.
What I'm seeking to do, no doubt very clumsily, I'm just seeking to show that, of course, the war in Ukraine is of huge foreign policy importance and huge importance to international peace and security. There's no question about that at all. But so were the issues at stake in these cases. And these were cases in which the court, we say, was prepared to apply a more interventionist test. And we're taking the test, we're taking these cases
I understand the point.
really as models to show that the learned judge was too cautious.
What I'm suggesting is the facts can't change the legal test. I mean, we need to establish whether you're right or Sir James is right as to the legal test, and then apply it to the facts. I mean, you know, unfortunately, in this area of law, sometimes the facts become so inextricably combined with the law that nobody seems to know what it is. But I'm just a simple private lawyer, and in my simple private law world, we find what the law is and then find what the facts are and apply the facts to the law. Apply the law to the facts.
Well, let me try and put it this way, Lord. One example of what I'm talking about. There is this issue, which I've referred to. It obviously played a lot on the judge's mind, so much so he wanted to give it close scrutiny. Which are the areas where I must defer to the Secretary of State, because this is all high policy, and which are the areas where I am entitled?
I completely understand your point that you've just made about two
and
paragraphs.
because to look at other cases where high policy was, in fact, arguably even higher policy was at stake, it may be instructive to see where those courts, where indeed the highest court, was prepared to draw that line.
Anyway, you had 5 points.
Yeah, I'm sorry.
In this case, and only got to 1.
Yes. Still reading from Lordship's description of himself as a simple private lawyer.
Well, you can take that away. Discuss it.
Just waiting for your Lordship to get me onto private law, and we'll see how simple you are. But so there was a public emergency threatening the life of the nation in Belmarsh. In the other, you had an Iranian bank which risked having its facilities used for Iranian nuclear weapons programs. Stakes pretty high by anyone's standards, and if ever there was fertile ground for pressing the need for deference, it was those cases. Second point, the human rights intrusions were comparable to, or lesser than, those in this case. Now, in Belmarsh, we accept there was physical detention for those who did not choose, as a number of them did, to return to their countries of origin. You'll remember this as the prison with 3 walls. Yes, detention is more extreme in its effects than financial sanctions, but bearing in mind the comments of Lord Hope, they are at least comparable. Then in Bank Mellat, there was at stake, pleaded by the bank, an annual revenue loss of $25 million a year, which did eliminate the bank's business in London, but which Lord Reid described as limited in the context of a bank with 2,000 branches, which had issued letters of credit in a single year to the value of $11 billion. That's Lord Reid at paragraph 127 of the Bank Mellat case. So that, we say, in the context of the business of Bank Mellat, could not be described as a more severe human rights intrusion than suffered here. Thirdly, in both cases, the court was influenced by the existence of other persons in comparable situations who had not been affected. Well, in neither case did this result in findings of unlawful discrimination. It did assist the court in coming to the conclusion that the decisions in question were arbitrary, irrational, and thus disproportionate.
I thought in Belmarsh there was discrimination on grounds of nationality. That was the heart of the reasoning of the House of Lords.
It was very strongly what influenced the court. But we'll look at how it's put and how the judgments are interpreted. And it was put, yes, as discrimination, but in the context also of proportionality. I better show you that so we can.
Well, also, I accept,
yes,
but not exclusively. There was found, correct me if I'm wrong, to be a breach of the rule against discrimination.
I think your Lordship's right. Yes, your Lordship is right about that. I may have misspoken earlier on. But it's certainly well established. The Bank Mellat case is a very good example. There are others, of course, in Strasbourg. I think the Gillen and Quinton cases in the bundle, I wasn't going to take Lordships to it, where the court says, well, the potential, at least, for discriminatory application of a law is one of the factors that renders it disproportionate. And that's why we don't give up, despite Lord Justice Lewis, entirely on what we have to say about discrimination. And this is not an opportunistic shift. We've always sought to introduce discrimination through proportionality, following Bank Mellat and Gillen and Quinton. But I accept what your Lordship has said. So in Belmarsh, the comparators were British citizens, and the argument was if it wasn't necessary to detain them without charge, how could it be necessary to detain foreign nationals? And in Bank Mellat, they were other Iranian banks who had not been subject to the same direction. Fourthly, in both cases, the court, even at the final appellate level, was acute to scrutinise the reasoning of both the Secretary of State and of the courts below, and to call it out where they found it lacking. In Belmarsh, the court went so far as to declare an Act of Parliament incompatible with the European Convention on Human Rights. And fifthly, these are not relics of some previous, more liberal age. Each of them was expressly relied on last year in the Abortion Services Northern Ireland case, in a speech of Lord Reid, judgment of Lord Reid, with which each of the other 6 justices agreed without further comment of their own. So these cases offer guidance not just because of what they say about the standard of review, but because of how they apply it in practice.
And do you also rely on the abortion services case, citing those earlier decisions in support of your submission that an appellate court is entitled to look again at the assessment of proportionality?
Yes, exactly, my Lord. And the Supreme Court was very clear on that. I'm in the court's hands. I was going to take you to those 2 cases in some detail. I'm conscious it's a minute to 1. I'm happy to make a start or to...
Well, I think making a start at a minute to 1 is probably, actually it's 2 minutes to 1, but let's try and start promptly at 2. Can I just take the time just to ask you 2 things, really? We now have the live stream working in Court 71. This court is hot and cramped, but I'm inclined to suggest we stay here today and move back to 71 tomorrow. Is that sensible?
So James is looking as though he may be regretting his thermal underwear. Certainly for my part, I'd be happy with either course.
I'm not getting into any of that.
He may wish to address you on this. He's not looking very pleased.
Is that a sensible idea to stay here today? We've moved once. Let's move overnight.
Yeah.
So we'll resume tomorrow in Court 71. How much longer do you think you've got? I mean, obviously you've lost a bit of time.
Yes, I'm afraid I probably will be
Most of
the rest of the day.
Okay. Well, we don't want to rush you. Thank you. 2 o'clock.
All right.